Yes. You know what was really nice about that meeting is I had Jack's own own exhibits to show. I didn't have to bring out my actual documentation that was served on me, Jill Landis. Church. I said, look at the public defender himself highlighted that the respondent did not receive actual notice of the hearing. Now, the court does not have jurisdiction over the parties, the minors, and the subject matter without the respondent receiving actual notice of the hearing. And the order was not issued in accordance with the full faith and credit provisions of the VAWA. That means you cannot probable cause arrest somebody for the domestic violence violation just because you decided to file a 2-count criminal complaint. See, the VAWA makes provision for probable cause arrest without warrant. Oh. But when you did your probable cause arraignment that I was the guilty party in violating it, you actually violated the requirement to have a warrant for my arrest before arraignment. Now, I mentioned to Jack, I said, Jack, you do realize that the police and sheriffs were never called. Oh, and it's a violent crime per se. Well, you decided to have an arraignment without any notice summoning me to have to appear in court without any proof of service. And with what evidence, since I emailed the police department? Exactly what evidence was there that I committed a crime when I was in Port Angeles, Washington that day? You know, I think one of the things that kind of surprised my public defender is I said, you do realize that June 16th June 16th of 2017 was my wife's 47th birthday. I think she was just fucking pissed off. Now, I don't know how you could actually arraign a person for a violent crime per se without a warrant for their arrest, giving you the authority to search themselves and anything involving themselves so as to have to arrest them for the probable cause arrest that the VAWA does not allow for the arraignment of individuals just because of a 2-count criminal complaint. I'm going to sue you for that. Do you understand what the law? Here's what the lawsuit is. Somebody alleged that I committed a crime, and the deputy prosecuting attorney decided that he would use his authority to file a 2-count criminal complaint and then not serve me, and then not investigate me. Now, I was looking over here. This is an amendment, the Constitution of the United States 2008 supplement. Yes. Let's say that the prosecuting attorney thinks you, Jane and John Doe Smith, have committed a crime. Decides to file a criminal complaint against you without informing law enforcement that it's a violent crime per se and having an oath or affirmation issue a warrant for the searching, the seizure, and the questioning of an individual named in a criminal complaint. Now, I know you'd say, well, prosecuting attorneys can name anybody they want in any criminal complaint without having a warrant for the arrest of the individual that committed the violent crime per se, without calling police or sheriff's departments. Yes. But the only reason that the Violence Against Women's Act allows for probable cause arrests, right, without a warrant is if law enforcement believes the individual committed a crime. Well, since you didn't give me any due process, since you served somebody else on August 27th, yes, since the petitioner didn't sign it, the actual criminal complaint that was filed in Jefferson County District Court happens to violate the requirements of the oath or affirmation believing that somebody committed a violent crime per se. Now, there is, well, I think it's in the Constitution. Yes, I do. When you don't call the police with the probable cause crime, serious crime per se, And there's no written report of myself being in Brennan, Washington, and then you don't go to oath or affirmation and have warrant issued believing the person committed a crime. I'm thinking these violent crime per se. Now, this is probable cause. Yes. An anticipatory warrant does not violate the Fourth Amendment as long as there is probable cause to believe that that the condition precedent to the execution of the search warrant will occur, and that once it has occurred, there is a fair probability that contraband or evidence of a crime will be found in a specified place or evidence. Now, how did I travel to Brendan, Washington? I borrowed a car from a friend. Exactly how the fuck did I get there and back? Now I'm going to sue you, okay, for filing a criminal complaint in a district court without any probable cause, arrest, or investigation of violent crime per se. And without a search warrant, that once it has occurred, there's a fair probability that contraband or evidence of a crime will be found in a specified place. An anticipatory warrant is a warrant based upon an affidavit showing probable cause that at some future time, but not presently, certain evidence of a crime will be located at a specified place. Yes. I'm almost sure that filing a two-count criminal complaint without issuing a warrant obligating me to be arraigned for the crime could be that there is missing evidence of the actual implications of the violent crime per se. Now, I am going to sue you for, he is going to sue you for arraigning the man without warrant from oath or affirmation or without probable cause declaration from law enforcement.